Good morning, Your Honor. Santiago Aroca. Santiago Aroca on behalf of the state of Florida.
You speak. Yeah, I speak English.
You need to stand behind the microphone.
Jose Alordigui for Mr. Rodriguez.
Thank you. Sir, you were arrested for second-degree murder with a deadly weapon and possession of cannabis with intent to sell. And I think we reset this from yesterday so that he can have his attorney present.
That's what I understand. Thank you, Judge.
Great. And you're here from the state?
Yes, Your Honor.
What do you want to say?
Yes, Your Honor. The state is traveling in this case under Section 4 of the murder statute, 782.04, felony murder. Felony murder, third degree, which is a second degree, is a misnomer, is Section 4, the last one. In this case, Your Honor, 2 persons were killed. There is a third one at the hospital in a very serious condition. We don't know what is, doctors don't know exactly what is going to happen to him. And Mr. Rodriguez was the person who provided the narcotics. Mr. Rodriguez arrived to this meeting to sell 2 pounds of marijuana with the pounds and with a revolver, with a gun. We have impounded the gun. It was in his car. Given the seriousness of the circumstances, given the participation, principal participation, so important of Mr. Rodriguez, who was the narcotics provider, he gave a full confession when he was questioned as to all these facts. These facts are not going to be very disputed. And taking into consideration his participation in previous drug dealings in similar circumstances and shootouts, the state is asking for a bond. He's entitled to bond, but the state is asking for a bond of $250,000 with a Nevia condition.
Okay. And you say, I'll let you ask questions as well or respond, sir. But I'm just trying to find out, the statute you're traveling under is 782.04?
782.04
Subsection 4?
4 is when a person dies during the commission of a felony other than the enumerated in subsection 2, which is the first degree felony murder statute.
So you're saying,
Subsection 3, I think is the one he's.
No, subsection 4, the last one. So section 3 doesn't apply because section 3 requires that the narcotics are the proximate cause of the death, which in this case is not. There was a shootout.
okay, so you're saying it should be the correct charge is not second-degree murder, but that it should be felony murder?
Felony murder, third degree, which is a second degree felony.
I understand. Thank you. Counsel.
Judge, when I referred to subsection 3, and here's why I don't think it falls under any of these statutes. Subsection 3 says that it's a felony murder if it happens during these particular listed felonies that are aggravated type of felonies. And the murder has to be committed by anybody present if it's a certain aggravated felony that's being committed. Now, subsection 4, which is what he is apparently his theory is under, is when it is any felony other than those aggravated felonies. But if you read it, it says the unlawful killing of a human being when perpetrated without any design to effect death by a person engaged in the perpetration. So it has to be, that's sort of an accidental death by the person perpetrating the sale of the cannabis. This was not an accidental death by Mr. Rodriguez. This was an intentional shooting by 2 people other than Mr. Rodriguez during the commission of this non-aggravated felony. I'll give you a moment to read that statute because it clearly doesn't apply.
Well, what about under what he can be charged for his conspirators or the other defendants? What their actions?
I think this is the statute. I understand, Judge, and I read the statute carefully, and I think it's pretty clear, especially read in conjunction with the section number 3.
You know, I disagree with that. Third degree felony, second degree happens when a murder occurs during the perpetration of any other felony than the enumerated felonies. That's what the statute reads. In this case, he was the drug supplier. He arrived to the meeting with 2 pounds of marijuana to sell to the buyers, and there was a shootout between the buyers and the sellers. So he was engaged in the perpetration of a felony, which is possession with intent to sell or actual sale of narcotics. That's the felony. And the death occurred while he was engaged in that perpetration. Doesn't have to have any intent to kill, doesn't have to shoot anyone. This is the scenario in which somebody is fleeing in a car for the commission of a felony and runs over an old person and kills that person. I mean, those situations happen quite frequently, and that's the statute that applies to those situations.
Counsel, any response?
No. I would have a response if you find probable cause to the amount that you may set in the bond.
All right, very well. I appreciate the argument that you've both made. Thank you. It's
Thank
not
you, Your Honor.
an easy type of analysis here. However, carefully looking at 782.04, I think the state has set forth a case, there's set forth probable cause for the charge of the felony murder because it's a murder in the third degree and constitutes a felony of the second degree based on what the underlying offenses of the sale, possession with intent to sell the marijuana. So do you want to tell me now what you believe the bond amount should be?
Yes, Your Honor, at least $250,000 with an AVIA. And the reason being that number one, the seriousness of the offense. 2 persons are dead. Another third person is at the rider, shot in the abdomen in a very serious condition. That's number one. Number 2, the participation of the offender. The offender arrived is the person who provided the narcotics. There is no dispute about that. Again, he arrived with narcotics. We have the narcotics. We impounded the narcotics in his car because he was able to run out of the place where the shooting happened with a gun. We have the gun. He gave a full confession of why he was attending. He was attending because through a broker, he was willing to sell the narcotics to these 2 Canadian boys. So he's really a principal to the offense. He participated to a great extent in the offense. Number 3, in the past, you see his prior, he was arrested for the same situation. There were no deaths in that situation before, but he's involved, as he knows, with his cousin in a very similar situation in which another person resulted death. So for all these circumstances, I believe that it's proper $250,000 to assure his appearance at trial of hearings with an AVIA, and that's what the state is humbly requesting from the court.
Thank you. Counsel.
Judge, he was present and allegedly, and I believe he stated he was selling approximately 2 pounds of marijuana. He left his firearm in his car. This happened inside a house. He had no intention to do anything. The buyer and another person present, the A form doesn't say who that person was, began shooting each other. They died. My client was just as surprised as could be. Now, he also is born in Miami, lifelong resident of Miami. His parents live here. He has a younger sister. They all live in one household. He has aunts and uncles here, and he is a U.S. citizen. So I would ask for $50,000. I think it's appropriate. It is a serious charge. I think that he's not going anywhere. And I would even suggest maybe an ankle monitor or house arrest.
Interesting. Spade, what if any thoughts on setting a lower amount and including house arrest as well?
He's a drug dealer. He has been a drug dealer for a long time. He has come to our attention 2 years ago in a very similar situation in the same area. This time was 19th Street. 2 years ago was 19th Street. 1 person died in those circumstances, very similar circumstances. I really believe, that number 1 is a risk of fleeing, number 1. And second is a very violent person. He goes to do drug dealings with a gun in his pocket. He knew what probably was going to happen. That's why he had a gun. I mean, and that's why it's the kind of things he does.
Excuse me, I thought you said he left his gun in the car.
He left the gun in the car, but he had the narcotics in the car because he didn't trust the buyers.
Oh, I understand.
So that's the kind of operation which nobody trusts anybody, okay? Operation between bad people, nobody trusts anybody, and everybody goes to firearms, and these things happen, unfortunately, too frequently, and it should stop. in our community these kind of shootings. And it happens constantly. It's a very substantial percentage of the murders we have, unfortunately.
Okay. Anything else?
Further. Never mind, go ahead.
Anything else, sir? I'm sorry.
No, Judge, the state's requested amount is not feasible for this
You're going to
family.
say it's tantamount to no bond.
Yeah, and given his ties to the community, given the allegations, and we're talking about 2 pounds of marijuana. It's not a trafficking amount. These are not. He's 19 years old. His family resides here and has for the last 20 years.
If I could say something, his family was here when he was a drug dealer. He resided at the same place than his family when he was a drug dealer with a gun. So why he's going to change now and he's not going to be a danger to the community? I mean,
I understand. I'll set
I'm
his
sorry, thank
bond
you.
at $150,000 with a Nebbia hearing. And plus house arrest.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Judge.
Oh.
That's count one, Your Honor.
You know what, count one, I'll set at $140,000, and count two I'll set at $10,000. So the total bond is $150,000 with a Nebbia hearing.
Thank you, Your Honor.
Thank you both.
With the Nebbia plus house
Plus
arrest.
house arrest, he can work only. Otherwise, it's total lockdown. Have a good day, sir.